If you're charged with a driving while intoxicated crime from operating a vehicle after having consumed alcohol, what are the penalties that are associated with resolutions on your case? Everyone wants to know, everyone asks when they come in. Oftentimes you get phone calls from somebody that's panicked on a Saturday night trying to figure out what's going on. Okay, so what happens? If you're charged on a first offense and your case is resolved with a driving while ability impaired resolution, that is a violation. It's not a misdemeanor. What does that mean? It means you don't have a criminal record. What are the penalties associated with a driving while ability impaired charge? Well, the fine is $300 to $500. There's a possible jail sentence of up to 15 days, and there's a license suspension of 90 days. There's a $250 surcharge that the court is going to implement. There's a $5 crime victim fee. There's a $250 driver responsibility fee that the Department of Motor Vehicles assesses over the course of 3 years. So that's $250 every 3 years. You can also be required to attend a victim impact panel and attend the drinking driver program. Your enrollment in the drinking driver program, assuming you're eligible, will provide you with the basis to acquire a conditional license. And I talk about that in another video if you want to view that one. What if it's a driving while ability impaired charge that you have to plead to or that you're convicted of after a trial? Okay, that is a misdemeanor. That means you have a criminal record. The penalties associated with that is that there's a $500 to $1,000 fine. There's up to 1 year in jail. There's up to 3 years of probation. There is a 6-month revocation of your driver's license. A revocation is different than a suspension. Why is that? A suspension, you just pay the fees and do the programs and your license gets reinstated. A revocation means your license is taken away and you have to get relicensed. So you have to go through the written test and the road test. And if there's other things that are problematic with your license, you haven't paid a ticket, you failed to appear on something, you have a suspension from something else, you're going to have to clear those things up in order to get your license reinstated. There is a $370 surcharge from the courts. There is a $25 crime victim fee. There is a $250 driver responsibility fee that's assessed by the Department of Motor Vehicles over the course of 3 years. The next step up is if your blood alcohol content is 0.18 or above. That means you were arrested, you were taken to the station, you blow into the breath test device, and you blow a 0.18 blood alcohol content. That's called an aggravated DWI. Your first offense is a misdemeanor. The penalties increase. There is a $1,000 to $2,500 fine. There is a year in jail possible associated with that crime. There is a 3-year probationary sentence that is a possibility with that crime. There is a 1-year revocation of your registration. There is a $370 surcharge. There's a $25 crime victim fee. There's a $250 driver responsibility assessment. You can be required to go to the victim impact panel. And now at this grade of a crime, the court is required to order that the interlock ignition device be installed in a vehicle that you own or is registered to you. The interlock ignition device is like a breath test machine that is connected to your vehicle, and you can't start your car unless you blow it into it and there's no alcohol in your system. The next step up is a driving while ability impaired by drugs. That as well is a misdemeanor. It's a $500 to $1,000 fine. It's up to a year in jail. It's 3 years of probation. It's a 1-year revocation of your license. It's a potential 1-year revocation of your registration on your vehicle. It's a $370 surcharge for the court. It's a $25 crime victim fee. It's a $250 driver responsibility assessment over the course of 3 years. Yes, there is a interlock ignition device that is required to be ordered by the court, and yes, you will be required to go to the victim impact panel. And again, if you are eligible, they will order you to attend the drinking driver program. Now we're done with the misdemeanors. How is it that you can be charged with a felony on a DWI? If you have a prior conviction within 10 years of the date of arrest of a misdemeanor, meaning DWI, aggravated DWI, DWAI drugs, or an assault 1 or 2 with a vehicle, you can be charged with a felony DWI if you were pulled over and it's 10 years from the date of that prior conviction to the prior arrest. You're within 10 years. You can be sentenced on a Class E felony with 1 prior misdemeanor for up to 4 years in state prison or up to 5 years on probation. The fine is $1,000 to $5,000. There is a 1-year revocation of your license at least. There is a 1-year revocation of your registration. There's a $495 surcharge. There's a $25 crime victim fee. There is a $250 driver responsibility fee for up to 3 years, and you would be required to attend the victim impact panel, and you are going to have to, the court's required to order the installation of the interlock ignition device. And last but not least, the highest grade felony is a D felony, DWI, and that's in an instance when you have 2 prior misdemeanors within 10 years from the date of conviction to the date of arrest on your new offense. You can be sentenced for up to 7 years in state prison. You can be sentenced to 5 years on probation. The fine is $2,000 to $10,000. There is a 1-year revocation of your license. There is a 1-year revocation of your registration. There is a $495 surcharge. There is a $25 crime victim fee. There is a $250 driver responsibility assessment over the course of 3 years. You are going to be required to attend the victim impact panel, and the court will also order the installation of an interlock ignition device in your vehicle if you're convicted on a D felony. What really happens in these instances? You don't often see with felony cases people serving extraordinarily long sentences of jail time. Sometimes it will be what we call a 6-5 split, meaning it'll be 6 months in jail and 5 years of probation. One of the other things that you don't see from the statutes is what goes into effect when you're placed on probation. Normally, one of the terms and conditions of probation is that you're not licensed. You aren't permitted to acquire your license to operate a motor vehicle regardless of your eligibility for the drinking driver program. One of your conditions on probation is going to be that you can't operate a vehicle, and that term could last longer than the year revocation that is in play with the statutes. So the long and the short of it is these are complicated situations, and if you are charged and you have a history of driving while intoxicated or driving while ability impaired charges in place, you need to have counsel and you need to talk to them as soon as possible so that you can determine what's going to happen in your life and with respect to your license and possibly your job.